A senior ditch day party goes horribly wrong when one of the high school students jumps into the pool and slams his head.
Well, now that teen is suing his friend's parents for negligence, claiming the parents did nothing to stop the reckless activity at that party. 12 News journalist Chase Golightly talked to that student's attorney.
It started off as a social media post made by a senior at Desert Vista High School telling other students they were having a party and to bring your own alcohol.
Party was a rager. They called it a dager, which means a daytime rager.
Attorney Brian Foster says it led to more than 100 teens packing the Ahwatukee home. Foster's now representing this 18-year-old student.
He and a bunch of other kids were jumping off the roof of this house into the swimming pool in the backyard.
This is video of that teen doing a front flip into the pool. What it doesn't show is that he missed, slamming his head into the pool deck, immediately knocking him out.
Had a concussion, had essentially his entire ear ripped off.
You can see others reacting, one jumping in to help. Foster says an ambulance was called and took the student to the hospital, where he did have a blood alcohol concentration of 0.114, more than the legal limit for someone who is legally allowed to drink. Foster says the medical bills are in the hundreds of thousands. He reached out to the homeowners for their insurance, but said they never responded, leading to this lawsuit against them, claiming the family supplied alcohol to the party, knew it would be consumed by minors, and they did not do anything to stop the alcohol consumption or reckless activities like jumping into the pool.
Clearly, my guy made a very poor judgment, and he will be held partially responsible for his conduct. But the overwhelming of fault, will be assessed to the homeowners for hosting an alcohol party for a bunch of 17-year-old high school students.
Given the circumstances, we reached out to another attorney, Benjamin Taylor, who has no relation to this litigation, asking him, since it was the parent's child who invited everyone, and these minors, including the victim, decided to drink and jump off the roof, if there is still a case here.
When your kids are having a party, even if you do not know about it, you still can be responsible. So even if your child invites other kids to the party and they mess up, under Arizona law, you as a parent can still be sued and still be liable for what your kid did if somebody got hurt, especially if they're a minor.
All right, so let's take a legal deep dive into this case. Criminal defense attorney Josh Colesrud is back. There is a lot to dissect here. First off, explain this law that, parents are still held liable even if the kids are the ones inviting?
Yeah, so in Arizona is a comparative negligence state, meaning that if there's a party at the parent's house and there are kids that are there drinking underage, drinking all that kind of stuff, the parents can be held liable for allowing it to happen if they knew it was happening. And that's going to be the question in this case. That is, what did the parents know and did they do enough to stop it?
Yeah, that's still the big question mark, obviously. But, at the beginning of Chase's piece there, he said that the kids, basically the invitation was like, bring your own alcohol.
Yeah, it seems like there's mixed messaging about what the parents knew or didn't know. So there is the text message where it said BYOC, bring your own alcohol, and that implies that everybody brought their own. However, in the complaint itself, it does say that alcohol was there and it was provided, although it does not state that the parents were responsible for furnishing alcohol to those minors.
Okay, so that's the difference right there. Now, but here's the thing. If the student who, obviously slammed his head, he was the one who chose to drink that alcohol. I mean, isn't he just as much at fault?
Well, that's for a jury to decide. Arizona, again, is a comparative negligence state. So let's say that the verdict is for $1 million in damages, and they say that the kid is 90% responsible for what happened, and that the parents are 10% responsible. He would still collect $100,000 from the parents because they were 10% responsible for the damages in the case.
Well, and even his own attorney had said that, my client he could see that he is partly responsible too.
Yeah, that was a smart thing to say because the jury is going to see this. He's jumping off the pool. He had a blood alcohol content of 0.114, well over the legal limit to drive. So obviously his client made some bad decisions that day. But what the attorney is saying is that despite these bad decisions, the gross negligence is what he said was in the parents' hands by even allowing this to happen. And so that's why he's bringing the lawsuit.
Okay, so bottom line, because, there are a lot of, whether it's graduation parties or holiday parties or what have you, what should parents know?
Parents should know that if you're over 21, you drink at somebody's house, you're fine with most things that happen. But if you're under 21 and you knowingly allow people to drink at your house, you're liable for anything that can happen to those people. If they drive and they get into an accident or somebody gets injured, they can be liable for those damages.
All right, Josh, great analysis. Thank you so much for your time.
Thank you.
Mark?
All right, Tram, thanks. Good stuff, Josh.